Welcome to another episode of California Crazy. My name is Jennifer, and welcome to Sweet Home California. Well, I'm taking a break on this episode. I might do another one later on today for the 10 bills that the People's Convoy was coming back to California and leaving DC for, and those were all pandemic related. This one just came on my radar yesterday, and this one is California Assembly Bill 2223, and it has to do with perinatal deaths. So in California, abortion is legal pretty much throughout the pregnancy. Uh, Perinatal uh, is a term that is defined by basically viability in utero all the way up to about 7 days after the child is born. So, Assembly Bill number 2223, a lot of the pro life uh, groups that I'm a part of started talking about this yesterday and saying that this was basically legalizing infanticide. Routers had apparently had a fact check saying that this was false. Tim Pool reported on this yesterday. That routers, Reuters, however you pronounce it, that they took down that fact check because after they investigated it, they was like, yeah, no, fact check true. But I'll let you decide. I'm going to try and minimize my own commentary on this because I know that this is probably a very sensitive subject for this particular platform. But if you hang on with me, there'll be a link down below that you can follow along into Rumble. And I will have some more commentary over there on Rumble. So, in any case, let me go ahead and get started with this. All right, so get this so you can read it. All right. So this is Assembly Bill 2223, uh, introduced by Assemblymember Wick with principal co-author Assemblymember Mullen. An act to amend Section 27491 of the Government Code and to amend Sections 103005, and I'm not going to read all that. But I will put a link in the description so that you can read all the details and everything. All right, so the Legislative Council Digest, it says that it will amend, as amended, it will make these following changes. So, number one, existing law requires a county coroner to hold inquests to inquire into and determine the circumstances, manner, and cause of violent, sudden, or unusual deaths, including deaths related to or following known or suspected self induced or criminal abortion. Existing law requires a coroner to register a fetal death after 20 weeks of gestation, unless it is the result of a legal abortion. If a physician was not in attendance at the delivery of the fetus, existing law requires that the fetal death to be handled as a death without medical attendance. Existing law requires the coroner to state on the certificate of fetal death the time of fetal death, the direct causes of the fetal death, and the conditions, if any, that gave rise to these causes. This bill would delete the requirement that a coroner hold inquests for deaths related to or following known or suspected self induced or criminal abortion, and would delete the requirement that an unattended fetal death be handled as a death without medical attendance. The bill would prohibit using the coroner's statements on the certificate of fetal death to establish, bring, or support a criminal prosecution or civil cause of damages against any person. Existing law, the Reproductive Privacy Act, provides that every individual possesses a fundamental right of privacy with respect to their personal reproductive decisions. Existing law prohibits the state from interfering with a pregnant person's right to choose or obtain an abortion before the fetus is viable or when it is necessary to protect the life and health of the pregnant person. Under existing law, an abortion is unauthorized if either the person performing the abortion is not a healthcare provider that is authorized to perform an abortion, or if the fetus is viable. Existing law, the Tom Bain Civil Rights Act, authorizes an individual whose exercise or enjoyment of rights secured by the Constitution or laws of the United States, or of rights secured by the Constitution or laws of this state, has been interfered with or attempted to be interfered with, to institute or prosecute in their own name and on their own behalf an action for damages as prescribed. So basically, if you interfere in any way, shape, or form, or attempted to interfere with, you could be sued by the person that you are interfering with. This bill would prohibit a person from being subject to civil or criminal liability or otherwise deprived of their rights based on their actions or omissions with respect to their pregnancy or actual, potential, or alleged pregnancy outcome, or based solely on their actions to aid or assist a pregnant person who is exercising their reproductive rights. The bill would clarify that an abortion is unauthorized if performed by a person other than the pregnant person, and either the person performing the abortion is not a healthcare provider that is authorized to perform an abortion, or the fetus is viable. The bill would authorize a party aggrieved by a violation of the Reproductive Privacy Act to bring a civil action against an offending state actor as specified, and would require a court, upon a motion, to award a reasonable attorney's fees and costs to a prevailing plaintiff. The bill would also authorize a person aggrieved by a violation of the Reproductive Privacy Act to bring a civil action pursuit to the Tom Bain Civil Rights Act. The bill would provide for the indemnification of employees or former employees of public agencies who are acting within the scope of their employment. So I guess if a police officer might not be able to be sued, but if you are part of a pro-life group and you are praying in front of an abortion clinic, and if someone thought that that was interfering with their reproductive rights, you as a pro-life advocate could be sued, apparently, under this Tom Bain Civil Rights Act. So, the people of the state of California do enact as follows. Section 1, the legislature finds and declares all of the following. A, that reproductive justice is a framework created by black women in 1994 to address the intersectional and multifactored issues that women of color and their families face in society. Never mind the fact that more black babies are aborted than are born. That part isn't in there. Sorry. Reproductive justice is the human right to control our bodies, sexuality, gender, work, and reproduction. That right can only be achieved when all people, particularly women and girls, have the complete economic, social, and political power and resources to make healthy decisions about their bodies, families, and communities in all areas of their lives. At the core of reproductive justice is the belief in the right to bodily autonomy, the right to have children, the right to not have children, and the right to parent the children we have with dignity and respect in safe, sustainable communities. C. A critical part of realizing reproductive justice for people in California is clarifying that there shall be no civil and criminal penalties for people's actual, potential, or alleged pregnancy outcomes. Across the country, people have been criminally prosecuted for having miscarriages or stillbirths, or for self-managing an abortion. California has not been exempt. Despite clear law that ending or losing a pregnancy is not a crime, police have investigated and prosecutors have charged people with homicide for pregnancy losses. Now, I agree that in the event of a miscarriage or a child dying, those are horrible things, and for a grieving parent to be accused of criminal conduct if they had nothing to do with the child's death is just insult to injury on that. However, is the answer to then now no longer investigate at all? What does that do to our value of life? I'd like your comments down below, but I'm going to try and minimize my commentary here. We'll do that later. Also across the country, pregnant people are under threat of civil penalties for their actual, potential, or alleged pregnancy outcomes, and civil penalties have been threatened against people who aid or assist pregnant people in exercising their rights. Pregnancies, paragraph F. Pregnancies can end in a range of outcomes. Nationwide, as many as 1 in 5 known pregnancies end in miscarriage. In California, as many as 2,365 pregnancies per year end in stillbirth, meaning perinatal loss after 20 weeks gestation. Many pregnancy losses have no known explanation. G. People also need to end pregnancies by abortion, including self-managed abortion, which mean ending one's own pregnancy outside the medical system. So a self-managed abortion means ending one's own pregnancy outside the medical system. This is their givens. This is their list of givens that people need to end pregnancies. Paragraph H. Every Californian should have the right to feel secure that they can seek medical assistance during pregnancy without fear of civil or criminal liability. Paragraph I. The threat of criminal prosecution of pregnancy outcomes is partly traceable to out-of-date provisions that give coroners a duty to investigate certain abortions and pregnancy losses. Based on these provisions, healthcare providers and institutions report people to law enforcement for pregnancy losses, leading to harmful investigations and even unlawful prosecutions. Civil and criminal penalties imposed on pregnant people is a critical issue for Black, Indigenous, and other people of color who experience adverse pregnancy outcomes as a result of systemic racial inequities and are more likely to be under scrutiny of state systems like child welfare and immigration. Paragraph K. The threat of criminal prosecutions or civil penalties on pregnant people through child welfare, immigration, housing, or other legal systems has a harmful effect on individual and public health. When a person fears state action being taken against them related to their pregnancy, they are less likely to seek medical care when they need it. If they do seek care, punishing them for actual, potential, or alleged pregnancy outcomes interferes with professional care and endangers the relationship between providers and patients. L. That is why major medical groups like the American Medical Association, the American College of Obstetricians and Gynecologists, and the American Public Health Association oppose civil and criminal penalties for actual, potential, or alleged pregnancy outcomes. Section 2. The Government Code is amended to read, and this is paragraph 27491. It shall be the duty of the coroner to inquire into and determine the circumstances, manner, and cause of all violent, sudden, or unusual deaths, unattended deaths, deaths where the deceased has not been attended by either a physician or a registered nurse, who is a member of a hospice care interdisciplinary team, as defined by subdivision G of section 1746 of the Health and Safety Code in the 20 days before death. Known or suspected homicide, suicide, or accidental poisoning, deaths known or suspected as a result in whole or in part from or related to accident or injury, either old or recent, deaths due to drowning, fire, hanging, gunshot, stabbing, cutting, exposure, starvation, acute alcoholism, drug addiction, strangulation, aspiration, or where the suspected cause of death is sudden infant death syndrome, death in whole or in part occasioned by criminal means, deaths associated with a known or alleged rape, deaths in prison or while under sentence, deaths known or suspected as due to contagious disease and constituting a public hazard, deaths from occupational diseases or occupational hazards, deaths of patients in state hospitals serving the mentally disordered and operated by the State Department of State Hospitals, deaths of patients in state hospitals serving the developmentally disabled and operated by the State Department of Developmental Services, deaths under circumstances that afford a reasonable ground to suspect that the death was caused by the criminal act of another, and any deaths reported by physicians or other persons having knowledge of death for inquiry by coroner. Inquiry pursuant to this section does not include those investigative functions usually performed by other law enforcement agencies. Paragraph A. If the coroner conducts an inquiry pursuant to this section, the coroner or a deputy shall personally sign the certificate of death. If the death occurred in a state hospital, the coroner shall forward a copy of the report to the state agency responsible for the state hospital. B. The coroner shall have the discretion to determine the extent of inquiry to be made into any death occurring under natural circumstances and falling within the provisions of this section, and if inquiry determines that the physician of record has sufficient knowledge to reasonably state the cause of death occurring under natural circumstances, the coroner may authorize the physician to sign the certificate of death. C. For the purpose of inquiry, the coroner shall have the right to exhume the body of a deceased person when necessary to discharge the responsibilities set forth in this section. D. A funeral director, physician, or other person who has charge of a deceased person's body, when death occurred as a result of any of the causes or circumstances described in this section, shall immediately notify the coroner. A person who does not notify the coroner as required by this section is guilty of a misdemeanor. Section 3, Section 10-3000 of the Health and Safety Code is repealed. Section 4, Section 103005, the Health and Safety Code is amended to read: A. The coroner shall, within 3 days after examination of the fetus, state on the certificate of fetal death the time of the fetal death, the direct cause of the fetal death, the conditions, if any, that gave rise to these causes, and other medical and health section data as may be required on the certificate, and shall sign the certificate to attest to these facts. The coroner shall, within 3 days after examining the body, deliver the death certificate to the attendant funeral director. B. This section shall not be used to establish, bring, or support a criminal prosecution or civil cause of action seeking damages against any person, whether or not they were the person who was pregnant with the fetus. Through its courts and statutes and under its Constitution, California protects the rights to reproductive privacy, and it is the intent of the legislature to affirm these protections. Section 5 of Section 123462 of the Health and Safety Code is amended to read: The legislature finds and declares that every individual possesses a fundamental right of privacy with respect to personal reproductive decisions, which entails the right to make and effectuate decisions about all matters relating to pregnancy, including prenatal care, childbirth, postpartum care, contraception, sterilization, abortion care, miscarriage management, and infertility care. Accordingly, it is the public policy of the state of California that A. Every individual has the fundamental right to choose or refuse birth control. B. Every individual has the fundamental right to choose to bear a child or to choose to have and to obtain an abortion, except as specifically limited by this article. C. The state shall not deny or interfere with an individual's fundamental right to choose to bear a child or to choose to have and to obtain an abortion, except as specifically permitted by this article. Section 6 of Section 123466 of the Health and Safety Code is amended to read: The state shall not deny or interfere with a pregnant person's right to choose or obtain an abortion prior to the viability of the fetus or when the abortion is necessary to protect the life or health of the pregnant person. Section 7 of 123467 is added to the Health and Safety Code to read: A. Notwithstanding any other law, a person shall not be subject to civil or criminal liability or penalty, or otherwise deprived of their rights under this article, based on their actions or omissions with respect to their pregnancy or actual, potential, or alleged pregnancy outcome, including miscarriage, stillbirth, or abortion, or perinatal death due to a pregnancy-related cause. Now, this is something that was changed. So apparently it had ended at death. They are now saying death due to pregnancy-related cause. So they are trying to limit this, no doubt based on a huge outcry, because as it read before, it didn't have, it could be a death for any sort of reason. So I'm really glad to see that at least they're trying to keep this to the scope of the pregnancy, and not necessarily, suffocation after the fact. B. A person who aids or assists a pregnant person in exercising their rights under this article shall not be subject to civil or criminal liability or penalty, or otherwise be deprived of their rights based solely on their actions to aid or assist a pregnant person in exercising their rights under this article with the pregnant person's voluntary consent. Section 8 of 123468 of the Health and Safety Code is amended to read, the performance of an abortion is unauthorized if performed by someone other than the pregnant person, and if either of the following is true. A. The person performing the abortion is not a health care provider authorized to perform an abortion pursuant to Section 2253 of the Business and Professions Code. B. The abortion is performed on a viable fetus, and both of the following are established. 1. In the good faith medical judgment of the physician, the fetus was viable. 2. In the good faith medical judgment of the physician, continuation of the pregnancy posed no risk to life or health of the pregnant person. So that's something I learned, that apparently it isn't just willy-nilly in California. There are some limitations on abortion in this state still. Section 9 of Section 123469 is added to the Health and Safety Code to read, A party aggrieved by conduct or regulation in violation of this article may bring a civil action against an offending state actor in state superior court. Apparently they were going to have it in federal district court, but they're keeping it at the state level, so they changed that. B. Whoever denies a right protected by this article or aids, incites, or conspires in that denial is liable for each and every offense of the actual damages suffered by any person denied that right, and, in addition, all of the following. 1. An amount to be determined by a jury or a court sitting without a jury for exemplary damages. 2. A civil penalty of $25,000 to be awarded to the person denied the right protected by this article. 3. Preventive relief, including permanent or temporary injunction, restraining order, or other order against the person or persons responsible for the conduct, as the complainant deems necessary to ensure the full enjoyment of the rights described in this article. Paragraph 4. Upon a motion, a court shall award reasonable attorney fees and costs, including expert witness fees and other litigation expenses, to a plaintiff who is a prevailing party in an action brought pursuant to this section. In awarding reasonable attorney fees, the court shall consider the degree to which the relief obtained relates to the relief sought. C. An action under subdivision B shall be commenced within 3 years of the alleged practice violation of this article. They have 3 years. Paragraph D. Subparagraph 1. A party aggrieved by conduct or regulation in violation of this article may also bring a civil action pursuant to Section 52.1 of the Civil Code, notwithstanding Section 821.6 of the Government Code. A civil action pursuant to Section 52.1 of the Civil Code may be based upon instituting or prosecuting any judicial or administrative proceeding in violation of this article. 2. For purpose of establishing liability pursuant to this subdivision, the criminal investigation, arrest, or prosecution, or threat of investigation, arrest, or prosecution of a person with respect to their pregnancy or actual, potential, or alleged pregnancy outcome constitutes, quote, threat, intimidation, or coercion pursuant to Section 52.1 of the Civil Code. Wow. Let me read that again. For purpose of establishing liability pursuant to this subdivision, the criminal investigation, arrest, or prosecution, or threat of investigation, arrest, or prosecution of a person with respect to their pregnancy or actual, potential, or alleged pregnancy outcome constitutes threat, intimidation, or coercion pursuant to Section 52.1 of the Civil Code. So that's a very chilling effect there. And then paragraph E, sections 825, etc. of the Government Code, providing for indemnification of an employee or former employee of a public entity, apply to any cause of action brought under this section against an employee or former employee of a public entity. which seems to contradict the paragraph immediately above that, because I don't see how anyone other than a public employee could bring a criminal investigation, arrest, prosecution, or threat of investigation, arrest, or prosecution. But I suppose that'll be for a judge to decide if this actually goes through. So these are all the changes that are in effect as of April 6th, the at 9 o'clock last night. Um, Last amended, yeah, it was on the 6th, and it has been to pass as amended and to be re-referred to the Committee on Health. There were 7 yeses, 2 noes, and 1 abstain. The 2 noes were Republicans, and the abstention was also a Republican. So we'll see where that goes from there. So anyhow, that is where that particular bill stands. So we have the state of Oklahoma, which apparently is signing into law basically banning abortion in the entire state. So we've got that one extreme, and then we have another extreme here where a child who dies within 7 days of birth, it makes it very convoluted and puts a lot of cold water on even investigating that sort of death. That's all I'm going to comment on YouTube. So goodbye, YouTube.